माननीय पटनायक जी, देवियों सज्जनों, आज 14 सितंबर है, हिंदी दिवस है। यदि मैंने आज अपना भाषण अंग्रेजी में शुरू किया तो मैं अपने को जीवन भर माफी, मैं अपना भाषण अंत भी हिंदी में करूंगा, लेकिन जो 20 का जो विषय है उसकी बातचीत चूंकि कानून से संबंधित है, मैं उसको अंग्रेजी में करना चाहूंगा। चलिए चलते हैं अंग्रेजी में आज के विषय पे। The last century was a century of resistance. If you were intelligent, if you wanted to change the world, the only subject that you chose was physics. But it is no longer true. This is the century of biologists, environmentalists. Environmental issues are going to dominate this century. Often, the state doesn't do what is required to do for environmental protection. They sleep over the same. They are guided by what politics? Immediate gains. It is the judiciary that's taking tough decisions, corrective measures. And that is why today's subject, the role of judiciary in protecting environment, is relevant and important. I'm sure when we hear Brother Patnaik, he's going to talk about those tough decisions. Because in fact, he is the one who's supposed to take them. He's heading the green bench. To my mind, is the most important bench in the country today, because what's our children going to have tomorrow, probably it might depend what he does today. But before I actually lay down a foundation to receive those tough decisions, listen to the tough decisions, I would like to talk about a little bit sustainable development, the most important concept in environmental protection. Sustainable development was conceptualized in Stockholm Declaration. Now, this declaration was actually the result of an international conference on human environment in 1972 at Stockholm, Sweden. This was the first major conference under the auspices of the United Nations on environment. It was actually a turning point on the international environmental protection. It started on 5th of June, and that's why 5th of June is celebrated throughout the world as a World Environmental Day. Sustainable development was given concrete shape in a report which was given by the World Commission of Environment and Development in 1987. This committee that gave a report was in fact chaired by Dr. Brundtland. She was the Prime Minister of Norway, and she resigned. She resigned being the Prime Minister of a country to become the Director of World Health Organization. That is why it is also known as Brundtland Report. The title of the report is very important, Our Common Future. It gave some of the salient features of sustainable development, also gave a kind of a define what is sustainable development. It says, sustainable development is a development to meet the needs of the present without compromising the capability of the future to meet its own needs. It also talked about 8 salient features of sustainable development. 1, intergeneration equity. 2, conservation of natural resources. 3, precautionary principle. 4, polluter pays. 5, environmental protection. 6, obligation to assist and cooperate. 7, eradication of poverty. 8, financial assistance to developing nations. These salient features were being recognized, enforced, accepted by a different decision of the courts. But the World Sustainable Development really got a judicial recognition for the first time in the Velos case. That was the case in 1996. There were tanneries in Tamil Nadu. They were releasing the waste effluents without treating them. And the Supreme Court sort of entertained it and established one of the salient features, that's precautionary principle. And it also elaborated it. It says environmental protection measures must anticipate and prevent environmental degradation. That's point number 1. 2, if there is serious threat or irreversible changes in environment, then take the preventive steps immediately, even if there is scientific uncertainty. Third was, it is up to the actor or industrialist to actually say that his action is benign. There's another salient feature of sustainable development, that's the polluter pays. And this was accepted in an enviro legal action case. There were certain chemical industries in Rajasthan, they were releasing toxic waste, and when it spoiled the soil, spoiled the water, and they closed it right away. The question arose, who is going to restore the land? Who is going to treat the water? And the petitions were filed, and ultimately the court held, they accepted the principle of polluter pays, and they said the one who pollutes, he is supposed to restore the land. He is supposed to pay the fines. It should not be shifted to the government, as that would be actually putting a burden on the taxpayers. All colors are beautiful, but the green is the most beautiful. It's the color of nature. And I'm privileged and happy to be the Chief Justice of a state where 44% is green, is covered by forest. We have to protect it. And the principle that trees are to be protected, biodiversity is to be protected, was actually strengthened in a series of orders in Bilaspur case. That's the case. The Supreme Court gave a very liberal interpretation to word forest in the Forest Conservation Act. It was held that the word forest in the Act actually conceives reserved forest, unreserved forest, private forest, government, all kind of forest it conceives. And if you want to do a non-forest activity there, you have to take approval for the center government. We have to preserve trees and biodiversity. And one of the principles which is applied there is a public trust doctrine. And this was actually applied, or I must say that, firmly established by Supreme Court in Kamal Nath's case. Now, there was a motel, and that motel had about 25 bighas of lease land in Himachal Pradesh. Almost all shares were owned by Kamal Nath, very powerful man, and his family members. Slowly, years to come, with the collusion of the officials, it illegally occupied another 27 bighas of land. And when Kamal Nath became the minister in charge for the Ministry of Environment and Forests, it granted approval for granting further lease of that 27 bighas of land, which was illegally occupied by the motel. Himachal Pradesh government, in fact, granted. The Indian Express was a newspaper which actually brought it up. Supreme Court read it, and thereafter the Supreme Court entertained a suo motu petition, and court applied the public trust doctrine. What essentially it says is, it's right, the state is the owner of all natural resources. It vests as a state, but they are not in fact the owner, they are in fact trustee for the benefit of the public. They are a kind of a public trustee. It is to be utilized for the benefit of public at large and not for the benefit of any minister concerned. The Supreme Court not only invalidated the approval, held the league to be illegal, cancelled it. Well, we should take environmental protection, measures should be there, we should also do many things. But suppose a disaster does take place, I mean, there too, Bhopal is one great example, then who's supposed to pay? During the 19th century, there was a very famous case, a well-established case, known as Ryland versus Fletcher. Now, this was a case where Ryland, who was a defendant, he constructed a water reservoir for his own land. He took reasonable care, very strong one. But his, below the surface, was a coal working. It had wooden shafts. Wooden shafts were slightly bold and they become weak. They gave way, and the water burst downwards. From that working, it went to the another coal working. From there, it went to the plaintiff's colliery and damaged. He filed a suit for damages. The matter went up to House of Lords. The House of Lords did uphold the damages. Nonetheless, it laid down the principle of limited liability. The liability was not absolute. It could, certain circumstances, be excused. However, our Supreme Court established the principle of absolute liability, and this happened in Oleum gas leakage case. In 1980s, Shriram Food and Fertilizer Company and Oleum gas leak, it caused injuries to the people, some damage there, and the question arose as to who will pay the damage. The Supreme Court held that if you are carrying upon a hazardous and a dangerous activity, then if something goes wrong and some injury is caused or some damage is done, then the liability is absolute. It is no excuse to say that you took reasonable care. And this judicially recognized principle was also given a judicial statutory recognition in the Insurance Public Liability Act as well as the Green Tribunal Act. The Supreme Court has established different principles. It is up to us to enforce them. But often, the people rush to the higher courts. There is no necessity. In fact, we have much better remedies available at the district level, and they should be utilized first. The reason is the local resident who is affected, and they can be better dealt with at a district level rather than 1,000 miles away in Supreme Court, or maybe about 400 miles in a High Court. In the Khachurulal case in 2005, the Supreme Court also explained about the details of these district court remedies. One, section 133 to 143, immediate removal of danger. And as a matter of fact, this was established in the Ratlam municipality case. This is a case where in the Ratlam there were a lot of problems. Public nuisance was there. There were not enough. There was not sewerage. There were not enough latrines. And the SDM passed an order under section 133 to improve the sewer system, drain the latrines. Unfortunately, a district judge, executive magistrate passed that order, but the district judge, as a misfortune will have it, he reversed that order. The matter went up to the High Court. High Court again reversed it back. Supreme Court upheld the order of the High Court. Such an order can be passed 133. 2. Suits under section 91. as a public nuisance can be fined. 3. Representative speech. Order 1, Rule 8. 4. There can be criminal prosecution also under Chapter 14 of the Indian Penal Code for creative public nuisance. Legislature can enact very fine laws. Judiciary can take very tough decisions. To my mind, it's not sufficient. It's not enough. Nothing can be done. Unless we as an individual also become a good environmentalist. What can we do about it? Well, just now a small note was circulated to you. Many years ago, we did a small talk with the Lawyers Club, and I was a member of that. We did one conference in which I did that. And if you look into that, it gives you about 14 tips to be good environmentalist. Try to follow as many as you can. I can't follow all of them. There are certain limitations of the office too. And when you are a lawyer, well, if you go on a cycle, you had it. No client will come to you. लगता है वकील just ये वकील साहब के पास तो पैसा ही नहीं गाड़ी खरीदने के लिए साइकिल पे चलते पेट्रोल का पैसा नहीं है. So that's a kind of showmanship is also required. That's another question. But I try to follow about 3-4 steps. And I hope after my retirement, I should be in a position to follow all of them. But suppose you want to take a particular action, which the step doesn't cover. What kind of thing you should do? Is there any principle to guide you? हाँ, जरूर है. एक principle है, सिद्धांत है. आप कभी भी कोई काम करें, तो आप हमेशा से इस बात का ख्याल रखें कि जो हमारी पृथ्वी माँ है, ये हमको अपने पूर्वजों से नहीं मिली है. वास्तव में पृथ्वी माँ को हमने अपने बच्चों से उधार ले रखा है. ये हमारे ऊपर है पृथ्वी माँ हम अपने बच्चों को कैसा देते हैं. क्या हम पृथ्वी माँ उनको ऐसी देंगे जिसमें पानी नहीं होगा, जिसमें हरा रंग नहीं होगा, जिसकी हवा ऐसी होगी जिसमें सांस लेना दुर्लभ होगा, या हम उनको ऐसा देना चाहते हैं कि सब लोग बाहर ही रहना पसंद करें. ये हमारे ऊपर है. और यदि इस सिद्धांत को हम ख्याल रखेंगे और हम अपने कार्य इसके मुताबिक करेंगे, तो मुझे कोई शक नहीं है कि न केवल हम अपनी आने वाली पीढ़ियों के लिए एक बेहतर जीवन दे सकेंगे, बेहतर संसार दे सकेंगे, पर शायद वो जरूर कह सकेंगे. बहुत बचपन में मैं सुना करता था एक गीत, जहां डाल डाल पर सोने की चिड़िया करती है बसेरा.